It's all about the money. This book explains everyday English, the federal publication up to 1986, and what bankers explained to Tom. Bankers told Tom that they want this to remain a secret. They even tried to get Tom to swear to secrecy. The bankers wrote the loan agreement. If it is good for America, why not explain all of the details to all voters? Tom says stop fighting the bankers and stop going to court. Court is risky. Use the banking system to your advantage, like the judge, lawyer, sheriff, politicians, and CPA, to accumulate wealth, or use the vote to change things. Money can control the media, politicians, judges, and the church. Today's banking violates the Bible as the church remains silent. Why silent? The church has a secret agreement with the bank, IRS tax deduction, to remain silent as the church gets financial benefit. 2 John 9:11 says, stop supporting the church with false teaching. If you obey, the church has to tell the truth or have no money to operate. Why does the bank need to control the church? The answer is in Revelations 13. Someone working with the government in 1982 was working on a national ID card to track all Americans by satellite. He was scared and explained how this would take all rights and freedom away. He said to expect a terrorist attack to convince Americans to accept the new slavery. Banks fear that the church will object, so the banks control what the preacher says by money. The IRS tax deduction. The IRS is the collection agency for the privately owned Federal Reserve Bank. Why support any church like this? Freedom cost. Bankers fear voters will learn the truth and reject the bankers' agenda. If you want to help us sell books and save America, send self-addressed stamped envelopes saying, I want to be a book reseller to Tom Shaw, care of P.O. Box 97015, Las Vegas, Nevada 89193 7015. Thanks for helping us save America. Distributed locally by. About the author. Tom Shaw has a diverse background. He graduated from Northern Illinois University with a bachelor's of science with double major in accounting and finance. After graduation, he worked as a staff accountant for Motorola. He worked for a small certified public accounting firm, owned and operated his own business brokerage firm, and certified public accounting practice. Over a period of nearly 10 years, he has testified in a number of cases as an expert witness in business valuations and has taught the arts of business valuations, business acquisitions, and negotiations to buyers, CPAs, and lawyers on a national level in colleges and major universities. He has taught lawyers and thousands of CPAs the art of valuation and negotiations in his copyrighted course designed to meet continuing education requirements. He has been a controller and the head of purchasing and personnel for a major manufacturing company. He was also a real estate broker and aircraft flight instructor, CFII. Disclaimer: people reselling the Top Secret Bankers Manual and books 1 and 2 may offer consulting services and or other products. Please be aware that Tom Shaw has no partners and that anyone you contract with for consultation or other services is acting as an independent agent. Tom Shaw has no control over what other people offer you as consultation, comments, advice, information, or products. Tom Shaw is not liable for what these others may offer or the result thereof. America's hope to cancel bank loans without going to court. Who funded the bank loan check? Borrower or banker? The bank loan concealment revealed. If the bank paid their debt, you would be out of debt. You be the judge and the jury and decide if a bank loan is bank robbery in reverse. Tom Shaw. Nothing But the Truth Press. Care of Tom Shaw, P.O. Box 97015, Las Vegas, Nevada 89193 7015. Notice, Mr. Shaw Mr. Shaw trained, hired, and paid an individual or individuals who signed an agreement of confidentiality to write for Mr. Shaw. The agreement prohibited the individuals or individual from writing commercially for others on Mr. Shaw's subject without Mr. Shaw's written permission. After receiving the materials, this party then refused to edit or write and wrote to Mr. Shaw explaining they would not honor the agreement and would use the money to write commercially for another. This information in this book is exclusively Mr. Shaw's property. It is illegal to make a derivative of this copyright. Please help us by informing us of any derivatives of this copyright. Copyright 1997 by Thomas D. Shaw. Copyright was transferred to and is owned by a trust. All rights reserved. No part of this book may be reproduced or transmitted in any form or by any means, electronic or mechanical, including photography, recording, or by any information storage and retrieval system without permission in writing from the author. Printed in the United States of America, 7th printing, April 2002. Contents. So we'll skip all these contents. Get right into the meat and potatoes. We're going to start 2023 out by kicking ass, ladies and gentlemen. America's hope to cancel bank loans without going to court. Introduction. If the government issued cash using United States notes, cash, interest-free, like President Andrew Jackson, President Abe Lincoln, and President John F. Kennedy, the national debt could be zero. Your personal income tax could be zero, and the average American could have very little, if any, debt. History shows President Kennedy was assassinated within a few months of issuing United States notes. Upon his death, President Johnson immediately replaced the United States notes with Federal Reserve notes. If President Kennedy had lived and continued printing United States notes interest-free, tens of trillions of dollars the banks now have would be in the hands of American citizens. If he had lived, the national debt could be zero and your personal income tax cut to zero. For every dollar of the United States notes issued by the government interest-free, the citizens have one less dollar of tax and one less dollar of debt. Economically speaking, a United States note gives the citizen an economic benefit similar to having gold or silver currency. Only the government can create money, giving bankers and non-bankers equal protection. Banks must only loan other depositors money and stop creating money like a counterfeiter. The banks demand that only they print the money and loan it to the government at interest, creating the national debt of $5 trillion at that time. The banks created money and loan it to citizens as they buy homes, cars, and farms. For every dollar the banks print and loan to citizens, the citizens have one more dollar of debt. The banks believe it is good business to create money, loan it out, and force you into more debt, paying them interest. If your neighbor could counterfeit money and loan it out at interest, he would be rich. If he was not stopped, he would end up loaning money to nearly every person owning a home, car, farm, or business. Nearly everyone in America would be paying your neighbor interest, or he would foreclose and own the property. This is why counterfeiters go to jail. Economically speaking, there is little or no difference between your neighbor counterfeiting money and the banks creating money and loaning it out at interest. The Revolutionary War was fought to stop banks from creating money and loaning it out. The Constitution allowed gold and silver as currency, prohibiting banks from creating money. This is why the media and the banks hate the Constitution. America's history shows that the banking system has changed from one where the government issues the money to one where the banks issue the money. When enough people wake up, the government will issue the money once again and the people will become debt-free. If we remain asleep, the banks will continue to create money and the people will end up having huge debts. The people are waking up once more, pushing for the government to follow President Andrew Jackson, Abraham Lincoln, and John F. Kennedy. All we need to do is follow these great American presidents and expose those who would support the enemies of our Revolutionary War. Educated people want United States notes issued interest-free, and the banks want to create money and loan it out. This is the secret to the media the media tries to hide. The banksters or bankers try to conceal, the judges ignore, and the lawmakers support. Obviously, they have a financial interest in creating money and loaning it out at interest. If the American population knew the truth and understood why we fought the Revolutionary War, they would vote out every lawmaker, judge, and policeman aiding and abetting the banks. This is why this book is sweeping the nation. People are talking and informing others. Brochures and cassette tapes are being copied and distributed. If we followed President Abraham Lincoln and the Constitution, and if the banks paid their debts, the national debt would be eliminated, personal income tax eliminated, and people would be out of debt in a short time. Please join us in exposing the truth. Be a leader. Tell your friends. Get groups of people to pass out the brochures, copy the cassette tapes, and lend out the books to others. When enough Americans learn the truth and what the media has hidden from us, every real American will want to follow President Jackson, Lincoln, and Kennedy and eliminate our debt. All freedom-loving Americans who believe in the Revolutionary War, the Constitution, and the Bill of Rights, join us in getting this message out so we can get the support of the American people. We cannot correct it if we all believe a lie, but we can correct it if enough Americans learn the truth and want out of their loans. If it will be up to you to save America. Teaching method. To make things simple, this book will begin with the basic concepts. These concepts will be repeated with new information added as we progress. Different illustrations will be added with more sophisticated arguments and teaching given. The goal is to have an average non-banker able to argue the bank loan agreement like a CPA expert witness. Key concepts will be repeated a number of times in various illustrations to be certain you understand the idea. If you do not understand the key concepts, you will be lost. For those who understand it the first time, please be patient with those who need repetition. About half of the population needs repetition to grasp new concepts, and many people who claim to understand without repetition find that upon being examined, they do not. It is important that bankers know this book explains to everyone exactly how to argue the bank loan agreement like a CPA expert witness. Experience has shown that even a competent CPA bank auditor occasionally requires 20 minutes of instruction on some of the concepts included in this book. While others understand these concepts immediately, therefore, we have chosen to repeat some of the materials more than once, in slightly different words and with different examples, to be sure that non-professionals can clearly grasp the information. The goal of this book is to arm you with the information you will need to argue against a CPA expert witness and win. Acknowledgments. Ancient history records, leaders like Hannibal and Caesar fighting against the bankers. No book would be complete without acknowledging the Bible's condemnation of today's banking system. Moses gave the bookkeeping entries of today's bankers and condemned it. History acknowledges Moses as the first lawgiver prohibiting today's banking system. The Apostle Paul called it a swindle. The Apostle Paul insisted anyone involved in this practice be thrown out of the church. President Andrew Jackson fought the money changers and won his battle. He read and believed the Bible. President Jackson followed the Bible's condemnation of today's banking system. President Jackson declared that the Bible is the rock on which our republic rests. I thank the President and Congress for making Public Law 97-280 and 96 Statute 1211 law proclaiming the Bible to be the Word of God. This law allows Americans to use their religious beliefs in condemning the banking practices. I thank Attorney General Janet Reno for her statement. It is very important that Congress represent the people of the United States and not one special interest group. I thank Judge Martin Mahoney for admitting that the banks operate contrary to public policy. Public notice. This book was not written with the aim of overthrowing the government. This book is designed to expose the truth of the bank loan agreement and illustrate its economic effect on Americans. It is explained in everyday terms that people can relate to and understand. This book is pro-American and proclaims Americans' right to free speech and the practice of religion. I am merely putting forward this information as part of my political platform as a candidate for President of the United States. This book is prohibited from being used in court. It is not designed to be used in court, and people are prohibited from using it as an exhibit in court. You may, however, take notes and use those notes, questions, and Federal Reserve Bank publications as court exhibits, but use of this book is prohibited. Upon receipt of this book, the reader agrees not to use the information contained herein as an exhibit in court. If the government, bank, or any other agency attempts to stop this book from being distributed by accident or design, or if I die or am placed in jail to silence this book, steps have been taken to copy this information and have it distributed from hundreds of locations throughout the nation. This will happen if there is any attempt to suppress this information. The banks may create a depression or a cashless society as a result of this book. We must inform as many Americans as quickly as possible to be sure everyone knows the truth and who to blame. I believe that if brochures are copied and distributed like wildfire, the banks will not dare create a depression in order to force us into a cashless society or try to call a constitutional convention to end our rights. America's future is up to you. Please spread the word quickly. Disclaimer. This book is based solely on the definitions as given in this book, as well as Federal Reserve Bank publications and standard bank bookkeeping entries. This book presumes equal protection under the law and that all material facts must be disclosed in an agreement. The basic presumption of this book is that a loan is not an exchange. I am not claiming that bankers, politicians, or CPAs are criminals. I believe the general public is misled as to the truth of the bank loan agreement regarding who provided the original capital in funding the bank loan check. The general public is misinformed as to the economic consequences of such banking processes. This book will not claim that bankers are criminals, but endeavors to show the general public the economic effects of a transaction according to the bookkeeping entries. The reader must use the glossary of terms unique to this book. Example, counterfeit is defined as private banks creating money, stealing, or theft is defined as banks obtaining the borrower's promissory note loan agreement without loaning 1 cent of legal tender or other depositors' money. The words counterfeit, theft, larceny, etc. have been used to describe similar or like economic effects. In this way, non-accountants can understand the real cost and risk of the bank loan agreement. I have written this book according to my research, belief, theory, and religious convictions. This book cannot be used in a government court as evidence. Attorneys representing banks may contact me to help stop this book from being entered as evidence in a court. I refuse to be the expert witness or testify in court unless I agree in writing and am paid to do so. This book was written to create a political solution, not to correct the bank problem in court. A political solution will save the economy and the nation. We must be responsible and protect the economy. I believe we have the best government and nation in the world, and we should use the vote we have to correct the nation's problems. Before one can vote intelligently, one must know the whole truth. The problem is that people believe that the bank agreement discloses all material facts. Borrowers would never dream that the Federal Reserve Bank publications show that the bank do the opposite of what most borrowers believe. This book will present evidence allowing the reader to be the judge and jury and decide for themselves if there is a fraud or not. According to certified public accounting ethics, I believe I must tell the truth about this banking system. No other party is to speak on my behalf. If I did not publish an idea or piece of information or place it in writing and sign it, I take no responsibility for it. I am concerned that people will misquote me or take my meaning out of context by changing one word, the entire meaning can be obscured. Therefore, I ask that people not quote me or this book. Do your own research before taking any legal actions. Tom Shaw is not giving legal advice. He is merely giving information to become elected. This book is based on information believed to be correct, but it is up to you to research it. It is possible that the Fed may change their publications in the future in order to change their previous quotes. This book uses information from Federal Reserve Bank publications up to 1996. After 1996, I do not know what Federal Reserve Bank publications will say. Do your own research. Definitions. The definitions of the words in this book are unique and only pertain to this book. It is suggested that one use a law dictionary for legal definitions of words used in this book. Agreement. Writing term and condition between two or more parties stating specific performance each party must do to bind the other party to the agreement. There is no agreement without mutual consent. There can be no mutual consent if there was a concealment and one party did the opposite of what was expected. Material facts must be disclosed. Authorization must be granted. Permission must be obtained, and adequate consideration, money, must be given to have an agreement. Example in the agreement: who was to provide the funds to issue the bank loan check? Was it the borrower or the bank? Was the bank to loan you legal tender as consideration loan to obtain the promissory note, or was the bank to loan you the opposite of legal tender? The cost and risk of the agreement changes significantly depending on the answer. Asset. Anything owned that can be sold. A car, house, legal tender, promissory notes, securities, and bonds can be sold, so they are assets to the one who owns them. Banks record legal tender as a bank asset. Banks also record owing legal tender as a bank liability. Bank agent. Anyone who benefits from the current banking system and or is responsible for enforcing the banking system. Bank employees, bank employees, police, attorneys, media, judges, lawmakers, and anyone aiding and abetting the trustees, Congress of the bankruptcy of the United States, anyone dependent or benefiting from the favors of bank money, either directly or indirectly, or loans to be in business, foreign agent or unregistered foreign agent representing a foreign interest, such as a judge, police, and attorney, as in USC Title 22, Section 610 through 615, or in any court case making them foreign agents or any other law. Bank-controlled media and publishing companies. Any media or publishing company that is biased in favor of the current banking operation or refuses to give equal time and representation to exposing the whole truth as outlined in this book. Media which has bank debt is dependent on bank to renew the loan or where the bank may withdraw the loan. Media which is dependent on advertising dollars whereby a bank can ask borrowers not to advertise with such media that exposes the whole truth and nothing but the truth concerning the alleged bank loans. Bond. A bond is a promissory note, an IOU, agreeing to repay the principal plus interest. Check. The Federal Reserve Board defines a check as a draft or order upon a bank or banking house purporting to be drawn upon a deposit of funds for the payment at all events of a certain sum of money to a certain person therein named, or to him or his order or to bearer, and payable instantly on demand. Definition as per Black's Law Dictionary. Please do not forget that the bank claims a banking liability is a debt. To make a checking account balance into money, equal protection must be denied, and money must be redefined to mean the opposite, or the promissory note is money or check kiting. It appears the bank may lead people to believe it is check kiting if one writes a check without first having a checking account balance, assets, to match the amount of the check. The check account balance has no value without legal tender, recorded as a bank asset offsetting the liability. The check merely transfers a bank liability checking account balance from one checking account to another. A check is not money. A check acts like money because you can exchange it for cash. Consideration. The reason for entering into the agreement, consideration, must be something of value, such as an asset or legal tender, cash. A check written without first depositing an asset, money, so that the check can be cashed is illegal consideration. If the check was the funds loaned to obtain the promissory note, then the promissory note cannot be used to fund the check. If the promissory note were used to fund the check, then the check cannot be the consideration loaned to obtain the promissory note, because the bank owned the promissory note before the check paid for it. Either the promissory note had to be loaned to the bank, or the bank stole the promissory note to fund the check. Stealing the promissory note means that no valuable consideration was given to obtain the promissory note. Counterfeit or counterfeiter. To forge, to alter or change a document after it was signed without knowledge or permission or authorization of all parties signing the document. An intent to deceive, bypassing the forged document as a genuine one that was not altered. Example: after the promissory note was signed, the bank stamps the back of the instrument, thus allowing the bank to use the promissory note to fund the check. The bank created money. Counterfeit money. For the purpose of this book, this means money banks created or caused to be created and loaned at interest. It does not necessarily mean the banks committed a crime. Credit. The postponement of the payment of money. The postponement of the payment of money cannot be transferred by check if a check must have a sum certain of money to make it valid. Is the promissory note money or credit? The definition of promissory note means the promissory note must be paid in money. How can it be money and mean money is owed at the same time unless there is more than one kind of money, legal and non-legal tender, at the same time? Damage. In court, you cannot win damage awards without showing you were damaged. One has a damage if one is the victim of the theft. The bank believes they were damaged if you do not repay the loan. Likewise, you were damaged if the bank did not loan you other depositors' money, or if the bank refused to repay the loan from you to the bank. Deposit. Money or negotiable instruments, checks, or commercial paper, promissory notes, handed to a bank. The bank credits a checking account, demand deposit account, savings account, or certificate of deposit, creating a bank liability. The depositor loaned the bank money or funds, allowing the depositor to withdraw the money deposited or loaned to the bank. Equal protection. Bankers and non-bankers having the same rights. Bankers cannot create money or credit and loan it out to non-bankers. Exchange. Trading value for value, the barter or swap. Example: you give the bank something of value worth $100 and they swap it for something of value worth $100, giving you back $100. A $100 loan is where one party hands $100 to another party to be repaid at a later date. Stealing $100 from one party and returning the $100 back to the victim is not a loan. The stolen $100 does not legally belong to the thief. It belongs to the victim. And exchange is not a loan. Chicago Federal Reserve Bank publication Modern Money Mechanics, page 6, claims the bank exchanged the promissory note for credit in the borrower's transaction account and called it a loan. The bank simply redefined the word exchange and called it a loan. The borrower hands the lender $100 and the lender hands the $100 back to the borrower, claiming the lender loaned the borrower $100. For this exchange, the borrower must pay a fee as if there was a loan. The borrower lost $100, the lender gained $100, and for this privilege, the borrower must repay $100 plus interest. Forgery. Counterfeit. Most people think it means your signature was signed by another person. However, a forgery includes changing a document after it was signed. When the document was signed and then altered, your signature becomes null and void. Fraud. Initially preventing the truth for the purpose of inducing others to rely on a lie or misinformation, false statements, or half truths and half lies, with the other party relying on such information to enter into an agreement in order to have the party part with something of value, such as a legal right or property. Knowing one will breach the agreement before entering into the agreement. Example, the bank claims they will make you a loan. The bank conceals that there is a loan from you to the bank exchanged for a loan from the bank back to you. It was concealed. The bank never loaned you 1 cent of legal tender that existed before you signed the agreement to be loaned as consideration to obtain your promissory note. The bank called and exchanged a loan and never repaid the loan from you to the bank. The bank received your property for free instead of loaning you legal tender to obtain your promissory note, thus changing the cost and the risk without the borrowers being aware. The bank's omission, concealment, false statement, and breach of the agreement changed the cost and risk. If people understood, they would have voted out every lawmaker, judge, and police officer aiding and abetting such a practice. This is why the bank hides the truth. Fraudulent concealment, the hiding and or suppression of facts which would significantly change the cost or risk of any alleged agreement to mislead the borrower as to which party applied the capital to fund the bank loan check, in or out of court, misleading or hindering the acquisition of information disclosing a right or transaction, an alleged contract or agreement, planning to escape investigation, suppressing the truth, or preventing inquiry to the truth. Interest, the charge for the use of borrowed money, not the opposite of money or the postponement of a payment of money. Larceny, to steal, theft by gaining possession of another party's property by using a trick, fraud, or policy or device designed to convert the property into another party's possession and having the economic effect of a theft. Depositing a promissory note instead of loaning legal tender to obtain ownership of the promissory note, placing an illegal lien on property without fulfilling the agreement, originating or reinforcing a false impression and not correcting the false impression or preventing one from obtaining the truth as to the correct information regarding the real cost and risk of the transaction in the alleged agreement, which might change the judgment of a party entering into the agreement. Example, was it an exchange and then charged as if there was a loan, or was there a loan? Who provided the capital to fund the check? Exactly who was to loan exactly what to whom? Liability. A bank liability means the bank owes a depositor legal tender cash. A liability is a debt, IOU, checking account balance, demand deposit account, savings account, certificate of deposit, or check, an unpaid obligation, a scorecard of how much legal tender or cash the bank owes depositors, a promise to pay. A liability is something you owe. A promissory note is owing money. A liability is a legally enforceable claim on the assets of a bank. Transferring a liability by check from one checking account to another checking account is not payment of a liability. The liability remains on the bank's books. Payment of a liability is proven when the liability no longer remains on the member bank's balance sheet. A bank liability is recorded in the accounting book on the far right-hand column of numbers. Lien, the right to someone's property or asset as a result of money they owe or are in default of paying. The bank receives the lien on your house if you take out a loan. If you do not repay the loan, the lien on the house allows the lender to foreclose and obtain the house. Loan, money or asset advanced or delivered to another party to be repaid at a later date with or without interest. The agreement can be expressed or implied. Example, if a bank receives a promissory note from a borrower and records the promissory note as a loan from the borrower to the bank assets and liabilities increase by the amount of the loan to the bank. When a bank claims it granted a loan, the bank's assets and liabilities increase by the amount of the promissory note. It is the same situation if the bank received the promissory note in a fraudulent conversion and loaned the value of the stolen property back to the victim. The question is, did the bank hide this transaction? Did the borrower give the bank permission? Did the borrower have knowledge? If there was no knowledge, how can there be mutual understanding or an agreement? Was it a loan theft or did the borrower have knowledge? According to the accounting records, it is either a loan to the bank or it is a theft. According to the accounting records, at a minimum, it is an implied loan to the bank because the bank recorded it as such. You have a right to receive the loan back in its equivalent in kind, meaning you have the right to receive the principal and interest paid to the bank. If it was stolen, most people would want their stolen property back. Misleading, delusive, to misrepresent, to deceive, and to lead astray. Money. As defined in this book, money must be a bank asset. In this book, the Federal Reserve Bank defines money as a bank liability. This book believes a bank liability is not money. For illustrative purposes, in this book, the word money can be used as the bank's definition of money being a bank liability. The point of the book is to show money legal tender is recorded as bank assets. Owing legal tender is a bank liability. If owing money is money, then it is the opposite of legal tender. The bank deals in legal tender and the opposite of legal tender, checkbook money, and call both money. Treasury notes, not Federal Reserve notes, are called United States notes. Promissory fraud. When the bank claimed that they would loan you a bank check payable in cash, and when the bank policy showed intent to breach the agreement and use the promissory note to fund the same check, that was to be the loan consideration for the promissory note. It was a misrepresentation of the lender's agreement and advertising. Promissory note. A promise to return money loaned to a borrower with or without interest, an unconditional promise to pay a sum certain in money. Please note, it does not say the opposite of money or credit, which is the postponement of a payment of money. Stolen. Theft, receiving something for free when you agreed to loan something of value. A plan to deny another party equal possession under the law, money, credit, or agreement to obtain something for nothing. A dishonest act or wrongdoing to willfully retain control of another party's property without authorization or beyond authorization and permission given, with intent to deprive the party of their property. For purposes of this book, stolen or theft means the bank obtained the promissory note or credit card agreement without earning the money to loan. Like non-bankers earn money and or without loaning 1 cent of other depositors' money, and by creating money or bank liabilities to obtain the bank loan agreement, promissory note, or credit card agreement. Example, the bank records the promissory note on the bank's assets and increases the bank's liabilities. The bank obtains the promissory note for free simply by increasing the bank's debt and not paying the debt and making it appear that the bank paid for the promissory note by transferring the debt to another person by means of a check. The banks could obtain the liens on the nation's assets and national debt simply by increasing the bank's debts and not paying them. To steal. Thief or theft. Obtaining the promissory note without the bank loaning other depositors money and by creating money having the economic effect of counterfeiting. Obtaining the promissory note by increasing the bank liabilities. To steal. United States notes. This book refers to silver certificates, greenbacks, and paper money issued interest-free by the government as United States notes. A note is an obligation. By being a United States note, it shows whose obligation it is to pay. Generally speaking, it is obvious that the United States notes is cash and is not paid but merely circulated as money or redeemed for silver or gold. For purposes of this book, we are only looking at general economic effect, not long-winded legal arguments on exact theories of paper money or gold and silver coins. Wealth. Property assets which has value and can be sold. Wealth includes your labor because labor is exchanged for goods and services. It's a value time commodity. People barter wealth for other people's wealth. For example, 10 chickens exchanged for one pig. Today, money is used to help facilitate exchanging wealth. These terms are designed to illustrate the economic effects of the bank loan agreement using everyday language. The author is not claiming the bankers are criminals. You are the judge and jury, and you decide whether there is fraud and whether we should vote to cancel your bank loan. High school pop quiz. Mr. Jefferson taught high school economics. The class was studying recession and learned that banks created recession to increase their profits and that recession and bank loans were directly related. Mr. Jefferson taught from the Federal Reserve Bank publications. After he taught the class about bank loans, he gave a pop quiz. Mr. Jefferson ordered his class to clear their desk and take out a piece of paper and a pen. He gave the class one easy problem. Using everyday language, explain the economic effect of a $100,000 bank loan. The first student wrote, "There are two banking systems. Under the United States Constitution, everyone has equal protection under the law. There is no economic effect of stealing or counterfeiting. The banks loan out other depositors' money to borrowers. We fought the Revolutionary War to stop the European banking system because it denies us equal protection under the European banking system. The banks do not loan other depositors money. The banks create the money like a counterfeiter and loan out the newly created money. Counterfeiting and stealing have the same economic effect because the bank ends up with nearly all the property for free. If a counterfeiter could create all the money he wanted, he would create money and loan it out. Soon, the counterfeiter would own the promissory notes, bank loan agreement promising to repay the loan, and the liens, a creditor's claim against your house or car to ensure repayment on the loan, on nearly every house, car, farm, and business in the nation. It is like printing money to buy all the property and renting it back to the citizens. The lender, counterfeiter, owns the liens and collateral, the interest for free, just like buying the property and collecting rent. It is like stealing the property and renting it back to the victim of the theft. Counterfeiting is more sinister than stealing. People can easily see an out theft and use their vote to stop it. Counterfeiting is not as easily seen. People think they are loaned other depositors' money, but the lender knows it is new money that was created as if by a counterfeiter. Modern day bankers know better than to counterfeit cash and go to jail, so they create checkbook money. They know your labor produces a payroll check. Your labor is worth money. American bankers merely shift the value of your future payroll checks to their pocket for free under the guise of a loan. Thus, they receive the liens on the nation's assets for free and charge the citizens interest on what was taken. Counterfeiting creates inflation and devalues money, destroying the property of other citizens. People are fooled into thinking that the banks give depositors interest so they can loan the money out. The truth is the banks agree to only create new money in relation to money on deposit. Example, if a bank has $1,000 on deposit, it can create $900 in new money, which people call checkbook money. They loan out the $900 of checkbook money, knowing few people use cash. People use cash for small purchases and checks for large purchases. Under the constitutional banking system, the people own their homes, cars, farms, and businesses with very little debt compared to European banking systems. In the European system, for every dollar counterfeited and loaned, at the moment the loan papers are signed, $1 of wealth is immediately transferred from the citizen's pocket to the banker's pocket for free. Just before the American Revolutionary War, the colonists used colonial scrip money under a constitutional banking system. In a sinister plot to obtain the colonists' property for free, King George of England forced the citizens into a European banking system, thereby allowing the banks to obtain nearly all the colonists' property for free and forcing them to pay interest on what was taken. According to the founding fathers, Benjamin Franklin, this was one of the primary reasons for the Revolutionary War. The Constitution prohibits the European banking system by requiring gold and silver money and equal protection. Imagine if Congress forced the citizens to surrender their assets to the bankers for free. Then the bankers returned the value of the assets back to the citizens as loans from the bankers to the citizens. Imagine Congress allowing bankers to legally steal or counterfeit. Mr. Jefferson was amazed to see how well the student understood the two banking systems and gave him an A. The next student wrote, think of the United States as a big casino. One can use cash to buy dinner or cigarettes. If you wish to play the slot machines, however, you must use casino tokens. There are two kinds of money: cash and tokens. Tokens are the private money used within the casino. Players trade $100 cash for $100 of tokens. The law requires the casino to have $1 of cash or cash equivalent at an asset that can be sold for cash on hand for every token the casino issues. If you have 25 tokens left at the end of the day, you may exchange them for $25 cash. Nearly everyone uses tokens because they are more convenient than cash. Merchants outside the casino accept them as money because their value is equal to cash. The casino bank offers loans of 100,000 tokens if the borrower signs a $100,000 promissory note agreeing to repay the tokens. The $100,000 promissory note can be sold for $100,000 cash. So the promissory note meets the legal requirements to be a cash equivalent. The casino uses the promissory note to issue and fund $100,000 newly created tokens. The casino received $100,000 value from the alleged borrower for free, used it to create new tokens, and returned the same $100,000 back to the alleged borrower as a loan. Receiving the promissory note for free is like receiving stolen property. Nothing of value was loaned to obtain it. The new tokens are like new money. Like counterfeit money, it is like stealing and counterfeiting rolled into one transaction under the appearance of a legal transaction. The agreement only agreed to use the promissory note to repay a loan, not finance new tokens given back as a loan. The tokens are not legal if the promissory note did not fund the value of the tokens. If the note funded the value of the tokens, the bank loaned nothing of value to the borrower. It is like depositing $150 with the bank, returning the $150 back to the depositor as a bank loan. The bank loaned nothing to own the $150 deposit. The bank does not legally own the promissory note until the bank fulfills the agreement and first loans $100,000 of actual cash value to the borrower. The borrower expected tokens to be backed by our depositors first depositing cash, not the casino owner using the value of the promissory note to fund the newly issued tokens. If the bank received the promissory notes for free, it is the same as a thief getting your future payroll check for free when they are used to make the loan payments. Stealing future payroll checks or stealing a car and selling it for cash and depositing the payroll checks or cash from the car's sale and then returning the money back to the victim as a loan is really stealing, not a true loan. Bankers know that no one in their right mind would agree to this, so the written agreement conceals the fact that the bank does not loan other depositors money and the bank gets the money from the borrower for free and returns it to the victim as a loan. If you replace the word token with the word checkbook money, you just described American banking. Mr. Jefferson was amazed at the student's insight and gave him an A+. Another student wrote, the bank acts like a money changer and charges you a fee as if there was a loan. You loan the bank a $100,000 promissory note that can be sold for cash, $100,000 cash. The bank invested nothing and records receiving the $100,000 promissory note as a loan from you to the bank, thus funding the loan from the bank back to you. A $100,000 loan from you to the bank was exchanged for a $100,000 loan from the bank back to you. It is like exchanging a newly created IOU for another newly created IOU. The bank demands that we use the bank's IOU as money counterfeit and the bank never pays their IOU. Then we must work to earn the bank IOU money to repay the principal and interest on the loan from the bank to us. The bank even got the people to call the bank IOU checkbook money. When people use checks, they use the IOUs as if it was money. It is like exchanging 100,000 of American money for the same value of German money and then having the bank charge a $100,000 fee plus interest for the transaction. It is like depositing $100,000 of future payroll checks at the bank and withdrawing the money as a loan from the bank to you. The teacher gave him an A. The next student proposed that it was like the old goldsmith of several hundred years ago. Everyone deposited their gold at the goldsmith for safekeeping. The goldsmith gave the depositors a gold receipt showing the amount of gold coins deposited. The merchant used the gold receipts like money, knowing they could exchange the receipt for gold coins. Soon, there were few people using gold coins. Instead, they were using the receipts as money. The goldsmith realized they could create gold receipts without actually having the gold to back it because few people ever asked to exchange the receipts for gold. The goldsmith advertised that they could loan money at 10% interest. People flocked to the goldsmith. Farmers agreed to lien their farms and sign promissory notes. The goldsmith created new money receipts, promissory notes, agreeing to pay gold coins. Because people use these receipts as money instead of gold coins, instead of loaning $100,000 of gold, the goldsmith received $100,000 in actual value of gold for free. He received the borrower's promissory note for free and could sell it for gold. The goldsmith created new money like a counterfeiter when he created new gold receipts, tokens, and loaned them out. If you replace the word gold receipt with checkbook money, you just described today's American banking system. Mr. Jefferson gave him an A+. He congratulated the students, saying that using the examples of gold receipts was an excellent way to explain the banking system. We will use this illustration pop quiz as a building block and add to this concept as we go along. 2. Secret bankers meeting. I believe we have the best government in the world. I personally believe that neither government officials nor the voters understand banking procedures and money transactions the way bankers do. I have talked to certified public accountants who were themselves confused. So I can certainly see how Congress and the president could be confused. This book is designed to clear up the confusion, giving you the methods to cancel the bank loan without going to court. To best illustrate the problem, I present the following hypothetical story. This book will prove that the economic and political effects illustrated in this story has happened in America. An investigation went out to the top bankers in the world, asking them to meet and discuss how they could work in unison to increase bank profits. A month later, a dozen of the top bankers met in secret. Before the meeting began, they stood around talking about the good old days. One of them said, if only we could create money and loan it out, that would increase profits. Another replied, if only we could become money changers, exchange $100 for $100 and charge 100 plus interest for the exchange. Yet another spoke up and said, how about making the borrower deposit $100 while we withdraw the $100 and give it back to him as a $100 loan? Doubting Thomas said, people would never be so stupid to allow us to do that. Richard, who called the meeting, rebuked him, saying, you're wrong, Thomas. I have devised a plan to do exactly that without the people ever suspecting that's being done or what's being done. Everyone, please be seated, and I will explain how we can end up owning nearly all of the wealth of the globe without ever loaning 1 cent of other depositors' money. We went to the front of the room and explained the following. Gentlemen, I have a bill in my hands that I wrote and that the Congress and the president will pass, making it legal for us to convert the property of the world into our hands without people ever realizing it. Today, the people own their homes, cars, farms, and businesses debt free because the government prints money like President Lincoln did. We will stop Lincoln's successor and ensure that only the banks can create money. We will then loan it out at interest. Every time someone receives a $100,000 bank loan, the bank will create $100,000 of money and loan it out. The people will have $100,000 of new debt that never existed before, while the bank will have a lien on their houses or farms. If they do not repay the loan, we get the real estate for free. When someone buys a house, they are dependent on obtaining a bank loan to purchase it. The average house sells every 7.5 years. So in less than 10 years, the banks will have these counterfeit liens on most homes. Every loan from a bank will ensure that the people will have more debt, not only in principal balance, but also by paying us interest. If they do not pay us the interest, we foreclose and take their property. In short, the bank creates the money and buys up the nation's assets, ending up owning nearly everything. Today, people can own a $100,000 house debt free because of Lincoln. Tomorrow, the same house will have a $90,000 mortgage on it, and the bank will receive a 10% interest. Each year, we will receive $9,000 of the homeowner's income for free, simply because Congress and the president will make it legal. We will have to breach the loan agreement, but since no one understands banking, no one will sue. Credit cards, student loans, car loans, house loans, commercial loans, and government loans will be financed by the money we create and loan out at interest. The new law will create a new personal income tax, IRS, so that the government will have the money to pay interest on the national debt that the banks will receive for free. The banks will pay 2.5 cents for $100 of cash. The bank will then loan the cash to the government to finance the government deficit. The government will give the bank back a $100 government bond and then tax the citizens $8. The government will give the $8 to the bank in the form of 8% interest, $8 on the $100 government bond that the bank received for 2.5 cents. It will be like the government giving banks the cash as a gift and the banks returning the money back as a loan. Soon the government will create a $5 trillion deficit by overspending, forcing the people to pay nearly 40% of their IRS tax to the bankers. We will force the wives to work as much as their husbands so that the banks can receive more profits. If a family has an income of $50,000, they will pay $10,000 in income tax. 40% of the tax, $4,000, will be paid to the banker for interest on the government bonds they received for 2.5 cents. The family will have a $100,000 house with a 90% mortgage, paying the bank 10% interest. So there again, the bank will receive $9,000 for free. 2 car loans, student loans, and credit cards would mean another $30,000 of debt, at least 10% interest, giving the bankers another $3,000 for free. The banks will receive an average of $16,000 from this family alone. Today, the banks get nothing, but when we get this bill through, we could get 32% of an average family's income for free. Another man, Frank, spoke up, explaining how the state, county, and city governments need loans just like the federal government. The banks, he said, will create money and loan it to the states, county, and local governments so that the American people must pay taxes to cover the interest on the money. The banks create and loan out. Government, in its biggest monopoly, all we have to do is get the money for free and loan it to the monopoly. Then we use the judges and police to collect the taxes, and we get nearly half of it back for free. To get the judges, police, and lawmakers to join us, we will show them how to profit from foreclosures. Sheer greed will enforce this banking system. The law will allow us to take from the Americans, putting their money and wealth into our hands without ever loaning 1 cent of other depositors' money. Many states have a 7% sales tax and a 3 to 5% income tax. The banks could get much of this tax once we get the monopoly into enough debt. Gasoline tax, utility tax, sales tax, real estate tax, and state income tax could be as high as 10% of a family's income. The banks could receive nearly 40% of the tax for free, which is 4% of families' income, added to the 4% to the 32% calculated earlier, and the banks could receive about 36% on average families' income for free. Doubting Thomas continued to argue that the people would never allow this and that the media would expose it even if it got through Washington, D.C. In response, Richard explained the major media is easily controlled. They cannot exist without bank loans either. They know that if they upset the banks, they will not get the loan they need to stay in existence. With all the bank profits and retirement money to invest, we can own a portion of the major media and publishing companies as well. Anyone speaking against the banks will be labeled as a conspiracy nut and an anti-government group that will shut people up. If we collect nearly 36% of the income of the families, we have plenty of money to become one of the largest political funders of presidents, Congress, judges, sheriffs, and other officials. They need the media and money to get elected. Let everyone argue over the little issue, but never allow the secret to be revealed. Anyone running for political office to correct our banking system will never receive favorable major media attention and will never get elected. Any lawmaker opposing the banks will get taught a lesson by having the media favor their opponent in the next election. The banking interest will simply withdraw financial support from those who oppose them and give financial support to political candidates who help us continue our banking system. Other lawmakers will learn by example, thus keeping them in line. We have to sell the idea to the American people without them understanding the truth. We will give the bank a name to make it sound governmental, making the people think it is federal, but it will be privately owned. The central bank will give back the government any profit, but the government cannot audit the bank, and the bank pays no IRS tax. We simply load up the bank expenses so there is little profit to give back to the government. Whether or not we give back profit is irrelevant. This just makes it look good to the public so they will not get wise and vote us out. The profit is in the local bank creating money and loaning it out. We simply deceive the people today. People think they can only deposit cash, checks, drafts, and wire transfers into checking accounts. The new banking law will allow us to deposit the bank loan agreement or promissory note contract borrower signed agreeing to repay the loan into a checking account. A $100,000 promissory note can be sold for $100,000 of cash or government bonds, so depositing a promissory note is just like depositing cash. The bank will receive a $100,000 promissory note from the borrower, deposit the promissory note, or sell the promissory note for $100,000 cash and deposit the cash. Then the bank withdraws the funds and returns it back to the same borrower, calling it a bank loan check. The bank never invests or loans 1 cent to obtain the promissory note. The promissory note acts like new money because it can be sold for money. The promissory note is deposited, creating a checking account balance, bank liability owing money. It has the economic effect of $100,000 of counterfeit money, or of stealing the $100,000 promissory note and returning the value of the stolen property back to the victim as a loan. Economically speaking, it is similar to stealing the victim's borrower's future payroll checks, depositing the payroll checks, and returning the money back to the victim as a loan instead of a return of the capital earlier deposited. The bank loans nothing of value, but obtains the promissory notes, liens on the nation's homes, cars, farms, and businesses for free. For every $100,000 loan, the people have an additional $100,000 of debt that did not exist before. If the people loaned their neighbor's money, or if the banks loan other depositors money, $100,000 is not shifted from the people to the bank for free. The bank loan agreement is the problem. We cannot explain the truth in the agreement. The bank must conceal and omit the part about the borrower being the lender, creditor, or depositor. If people understand the truth, they will never agree to it. Mike spoke up and explained that if the bank was to be truthful in the bank loan agreement, it would say the bank loans no legal tender or other depositors' monies to fund the bank loan check. The borrower agrees to loan the bank the $100,000 promissory note, and the bank loans the same $100,000 back to the borrower. The borrower must repay the loan back to the bank, but the bank never repays the loan from the borrower to the bank. John was so excited he jumped up, interrupting Mike. It is like the borrower is asking for a $100,000 loan. The moment the borrower signs the $100,000 promissory note, they have created a paper that can be sold for $100,000 cash, because the promissory note has interest and investors will pay $100,000 for the $100,000 promissory note. The investor's money is safe because of the collateral, which is the lien on the house or car. If the borrower does not pay the loan, we foreclose and get our money. The bank loans nothing. It simply deposits the $100,000 and withdraws it again, returning it back to the borrower as a bank loan, as a bank loan check. The new $100,000 acts like new money. The bank gets $100,000 check and the $100,000 promissory note for free. The bank gets the borrower's future labor for free, or the bank forecloses and gets his or her house for free. The bank does not give up $100,000. They receive $100,000 and return it as a loan to anyone stupid enough to give them $100,000 in the first place. Sam said depositing the promissory note is like depositing cash because it can be sold for cash. Banks sell depositors cash for government bonds to get interest. So we will not only deposit cash, we will deposit the promissory note and then sell the promissory note for government bonds. It makes no difference whether cash or promissory note are deposited. We sell both to get government bonds that can be sold later for cash if we need it. Depositing a $100,000 promissory note is like depositing new money, creating a new deposit. Then the check is written from this new deposit. The check has cash behind it, so it is not check kiting. We loan nothing for the promissory note. We get it for free and then loan it back to the one we stole it from. If we can keep stealing and returning the value of the stolen property back to the victim as a loan, the bankers will end up owning the world for free. We can control everything. Joe explained what he loved most about the idea. It is too confusing to explain this to a jury. If we foreclose, the victim has no money to take the bank to court and hire an attorney and expert witness. Peter was sitting quietly in the back of the room thinking. He said, "Let me get this straight. On a national level, the government gives us $100 cash for the cost of printing it, and we loan it back to the government, who gave it to us for free or printing cost. And when local banks grant a $100,000 loan, the borrower gives the bank $100,000 for free, and the bank returns the $100,000 back to the borrower as a loan." James interrupted and asked, "How can the bank receive $100,000 from the borrower for free when the borrower needs money and is going to the bank for a loan?" Charles spoke up and said, "The minute the borrower signs the $100,000 promissory note, the note can be sold for $100,000 cash. When you deposit the cash or promissory note into a checking account, there is a new checking account balance of $100,000 that acts like money. It is like creating 100,000 of counterfeit money. Whatever is deposited by law becomes the bank's property. People use checks to buy things instead of cash, so we do not need cash. We need checkbook money." James spoke up and said, "It is simple. The government or the people give us money or something that can be sold for money, and we get it for free. Then we return it back to the same person and call it a loan. The people will never figure it out because they think it is a loan. We will simply conceal the fact that we took the money we are lending from the borrower himself. If the borrower has no idea they gave us something and no idea that what we did with it, we can do it all day long. Richard, otherwise known as Dick, also, all we have to do is promise that the politicians' money to get elected. When they retire, we give them consulting fees and make them rich for passing the laws that take from the American pocket and put into our pocket for free. Money will control the media. Those who understand the system will become rich at the expense of the ignorant. Debbie finally piped up and said, "You haven't even seen the best part yet. I used my economic background to write up the banking manual showing banks how to expand and contract the money supply, forcing Americans into foreclosures and bankruptcies. Banks can create planned recessions and depressions to own the wealth of the nation for free. Our plan is to foreclose on all farms, ranches, homes, cars, and businesses. What Americans own today will be ours tomorrow simply because a private organization will control the money." Richard concluded the meeting by making everyone take a vow of silence on the subject. One cannot prove that this secret meeting or one like it ever occurred, but one can look to see if the results predicted in such a meeting occurred. This book will prove that the economic effect of the plan discussed in the meeting has occurred in America. Once you learn the banking secret, you can help foreclosure victims and legally divert money from the banker's pocket back to the citizens where it belongs. When we come back, we'll be talking American Banking System on Trial, number 3.